Okay, good afternoon to everybody who's on the line. Thanks to everyone for joining in today. Hope everyone had a great Thanksgiving weekend. I'm sure that you're all pleased to be spending at least part of it thinking about the Fair Labor Standards Act, as of course we were here on our end. My name is Brian Turoff. I'm a New York-based partner in the Labor and Employment Group at Venable. We're joined today also on the line on our end by my colleagues Ron Taylor, Doug Mishkin, Robin Burroughs, and Allison Gotfried, who are also members of our nationwide labor and employment team and will be presenting today along with me. As you know, what we're going to be discussing today are the implications of this past Tuesday's federal court decision, which blocked, at least temporarily, which is an important point to keep in mind that we'll touch on again, the implementation of the Department of Labor's final rules regarding what were intended to be changes to the salary threshold for the FLSA's white-collar exemptions. And those, of course, are the exemptions for employees who are categorized or classified as administrative, executive, or professional. We're going to start with, and I'll actually forward the slide here to give you the overview. We're going to start with a bit of background on the final rules themselves, some information about the cases that were filed, challenging them, and an overview, of course, of Tuesday's decision. And after that, we'll talk about some of the practical implications of that decision, and of course, what your options are now as employers, which we would assume is probably a primary point of concern and probably focus for you, particularly over the past days since the decision. And as we wrap it up, we will also be sure to leave time for questions at the end. Let me forward our slide here. So to give you a little bit of background, and many of you I realize on the line may know a little bit about this, if not a lot. Historically, really since the late 1930s, I think it was 1938, this first came into existence. Under the FLSA, in order to determine whether an employee was exempt under any of these white-collar exemptions, you really had to satisfy two criteria, one of which is essentially a threshold question. The first is that the employee has to be paid on a salary. That salary had to be a certain level, which over the course of time has been increased 7 times, the most recent time being 2004. And of course, assuming the employee is actually paid that salary, the question then becomes whether or not he or she is performing duties that would properly render them exempt under one of the white-collar exemptions. As the test, and particularly the salary threshold, at least arguably began to become antiquated over time, in July of 2015, the Department of Labor published a notice of proposed rulemaking essentially announcing that they intended to make changes to the exemption test. I'm actually reading here from the Department of Labor's, from the actual notice, and in their words, the explanation was the department seeks to update the salary level to ensure that the FLSA's intended overtime protections are fully implemented and to simplify the identification of non-exempt employees, thus making the white-collar exemption easier for employers and workers to understand. In that notice, they also referenced the fact that they are proposing to automatically update the salary level to prevent it from becoming outdated, which of course was a touchstone in the court's ultimate decision last week. And they also mentioned that they are considering whether revisions to the duties test are necessary to ensure that those tests actually reflect the purpose of the exemption. In the ensuing, that was July 6th of 2015. The notice and comment period that came after that extended just about 2 months to September, almost exactly 2 months to September 4th. In that period of time, the Department of Labor received 270,000 comments in connection with the notice of proposed rulemaking. And in May of 2016, they announced their final rules. The final rules, as I'm sure the people on the line know well by now, increased from $455 a week, which was again a threshold that was established in 2004, increased from $455 a week, which equated to about $23,660 annually, increased that from $455 to $913 a week, the minimum salary that had to be paid to employees in order for them to even be considered as possibilities of falling within the white-collar exemptions. That $913 a week salary, which equates to $47,476 a year, would then automatically update every 3 years beginning on January 1st, 2020. Interestingly, despite what you heard was sort of the pronouncement of the Department of Labor in issuing the notice of proposed rulemaking, no changes were ultimately put in as it relates to the primary duties test. As a side note, the Department of Labor also changed the thresholds as it relates to employees who are treated as highly compensated, which you can see on this slide. That threshold had been $100,000, and it will now be, or was intended to be, increased to $134,004. And those new rules were intended to go in place on December 1st, 2016. From that time on, as we know well here at Venable, and I'm sure you've been dealing with this in the ensuing period of time, we have worked together with employers, and you have worked internally to begin preparing for the changes that the Department of Labor had announced. And depending upon the industry you're in, the nature of your business, how many exempt employees you have, those changes were probably fairly wide-ranging. They could include changes in shifts, changes in the classification of employees, and of course, we were right at the point where that was about to become real, were it not for a lawsuit that had been filed. So in September of this year, two separate groups, which really consisted of 21 states, and then on the other hand, a group of dozens of business organizations, most notably various chambers of commerce, filed two separate lawsuits in Texas federal court that sought to enjoin, to block the implementation of that final rule. Those lawsuits, incidentally, were then consolidated by the court into one. There were a range of arguments that were raised by the parties in those lawsuits, which amounted, you can see the list on the slide right now, some of which were suggesting that the Department of Labor was essentially circumventing the notice and comment process, which is required by the Administrative Procedure Act, which basically says, you know, before you change this kind of stuff, you gotta put it out for comment first. Whereas the automatic escalating salary figures that would have been in the new rules essentially circumvent that. Arguments. You also had business organizations and the states as well arguing that the costs that would come with this would be prohibitively expensive. The states in particular raised arguments that were essentially focused on federalism ideals, which basically says the federal government is reaching into our coffers and making us spend more money than we either want to or in some instances are able to, and essentially manipulating and undermining our budgeting process. An argument that you heard in particular was the suggestion that by raising the threshold to $913 a week, which at least according to the plaintiffs was an extraordinarily high threshold, that it was essentially supplanting the duties part of the test, which was required by Congress. That essentially if you have people making that much money, you wouldn't even really need to assess whether they're doing the duties that would satisfy the exemption test, that it would be obvious that they would be doing that, which we subsequently saw was something that the court was very receptive to. As a result of those lawsuits, and in particular a request by the plaintiffs for a preliminary injunction, on November 22nd, which of course was this past Tuesday, leading us all to Thanksgiving weekend, the court rendered a decision on the plaintiff's request for a preliminary injunction, and as we know now, and of course explains why we're all here on the telephone, the decision that the court issued was to issue a nationwide preliminary injunction that prohibited the implementation of the final rule. And you can see some notes here on the slide. And the court, as I mentioned a moment ago, the court, among other arguments, was receptive to the idea that the raising the minimum salary threshold for those exemptions essentially supplanted, or at least arguably supplanted, what is the second part of the test, which is the duties test. They also were receptive to the argument that having automatic escalators in the salary threshold, which would have taken place every 3 years, essentially circumvents the notice and comment period that's required by the Administrative Procedure Act. And they were receptive as well to the fact that if the rule were allowed to go into effect on December 1st, that the harm that would be done to the plaintiffs, the business organizations, the businesses themselves, and the states would arguably be irreparable, whereas the comparable harm to the Department of Labor or to the workforce would be comparatively much smaller, if not minimal. It is important to recognize it, and I'm going to turn things over in a moment to Allison and Robin. It's important to recognize that right now the decision that was issued does not end the case. The implications are obviously significant. As I said, it does block the implementation of the rule. This is not the end of the issue. This is an injunction that will remain in place for the duration of the case itself, but it does not mean the case is over. There will be continued argument and litigation over the case that will continue, I would imagine, at least for a period of months going forward from now. But not until a final decision has been actually issued in the case will we know for sure what the fate of those rules will actually be. So let me turn things over now to Allison and I think Robin together to talk a little bit about, as you can see on this slide, what's going to happen next. And after that, we will talk a little bit about given those factors, what should you do or what sort of things should you be considering as your next steps.
Thanks. Hi, everyone. So I just want to talk about something that we had mentioned before, was that the original date for the implementation of this rule was December 1st, which would be this week. And as you can see from this slide, something that's very important to realize is that this doesn't actually permanently override the final rule. So the final rule, the status of the final rule is actually now up in the air. And what happens with this preliminary injunction that's been granted is that it essentially postpones the date of implementation until after this December 1st date, barring other litigation that might take effect. So that leads us to our second bullet point, which is the decision may be challenged by the Department of Labor. So in addition to the continuing litigation on the actual substance of the case itself, the Department of Labor has the ability to appeal this preliminary injunction, and I believe they have 60 days to do that from entry of the preliminary injunction. And so that takes us to around the end of January, where somewhere in between now and then we will find out whether or not the Department of Labor intends to appeal the preliminary injunction itself or just simply continue on with the litigation as it was originally filed.
Sure. So as Allison was saying, this does delay implementation of the new regulation past the December date. As an employer, that doesn't mean you have an obligation to unwind any changes that you have planned. But if you do want to do that, you must still comply with the current overtime regulations, the one that Brian was saying were set out in 2004. So the salaries test will still exist while we're in this period of uncertainty. The salary is the lower $455 a week, or about $23,000 annualized. And your employees still have to meet the duties test. They can still be exempt, and that will be the regulation going forward for the moment. As Allison was saying, we are unlikely to see a final resolution before the new administration takes command on January 20th. Obviously, President Trump will have a different agenda than President Obama has, but it isn't 100% clear that that agenda will involve challenging or rolling back these regulations. He has stated that he has some concerns about them, but he also did get a large segment of his vote from people who would have benefited from these regulations. So there's a lot of speculation about what he might do, and right now it's unclear which route he's going to go. Either way, he can't just change the rule with a stroke of his pen. So this could linger for this indefinite period we're in, could linger for a while. Brian outlined a bit of the notice and comment period. That's one way that a new Secretary of Labor, once confirmed, could make some changes to these regulations. The court case could play a role in the outcome. There are really just a lot of unknowns at this point. So nothing Trump can do on January 20th will change the course of these regulations on that day. So we really just need to, all of us, be paying attention to what is happening in the lawsuit, what is happening in Congress, what is happening in the Department of Labor, to see where this is going to go and where it's going to come down finally.
Okay, and one of the last point on this slide is that states it's the state's prerogative to amend their own laws to make them more strict or more pointed on this issue. And we see that in the minimum wage context, where states set their minimum wages higher than the federal minimum wage, and that happens a lot. And a recent example of this is New York actually recently proposed an amendment to their state law their state labor law that sets out these exemptions in the state context. And it would actually increase the minimum to higher than what this final rule, the minimum salary threshold, to the higher than what this final rule proposes. And so that's an example of a state kind of taking the matters into their own hands and ensuring that the employees within that state do reap some of the benefits that this final rule intended.
Yeah, and I think, as Allison said, we're starting to see that. As Allison mentioned, the New York law. Some of you may already have received the alert that we had sent out about the New York specific one. I think many of us on the line, at least on our end, would not be surprised to see something along those lines, not just in New York. I think California is probably the reason why. I think you're likely to see those sorts of things, obviously, in cities that, where a lot of you probably do business. And again, I think you're likely to see that coming down the pike quickly, but I think that you'll probably see an even greater escalation of that in the event that something happens, whether it's by way of the administration or it's by way of a decision in the case that ultimately either changes or eliminates in its entirety these final rules. I think at that point you'll see the states, and as Allison mentioned, one of the important takeaways on that front is that the thresholds that the states may establish, and we've certainly seen it already in the case of the New York regulation that's making its way through the process, the thresholds there may be even higher, and frankly are likely to be higher than the thresholds that were proposed in connection with the federal rules that are now obviously subject to the injunction. So let's move forward here to some questions and to a topic that I think is probably touches on the primary concern of the people who are joining us today and employers really around the country, which is, what do you do now? So we know that the injunction is in place. We understand what the background is. We understand what the possibilities are. But we also understand that in a lot of respects that leaves you as employers in a fairly touchy state of limbo. You're in a state of limbo as it relates to what do you do to comply with the law. You're in a state of limbo as to personnel relations issues and the fact that complying with the law is not quite as simple as just saying, okay, well, the court said this, and so that's what we're going to do, because there are real people who are affected by this, who are sensitive to what's happening. So let me sort of direct this question now to Ron Taylor in our Baltimore office. Ron and I have talked about this quite a bit. Ron, if you could talk for a minute about the real life options that employers have, that would be great.
Sure. Thanks, Brian, and good afternoon, everyone. Right now, many of you are probably thinking that this is like a test that you have studied for that gets canceled or postponed at the last minute. And whether you are elated or disappointed depends quite often on your degree of preparedness and how much you had done to get ready for that test. Obviously, if you've done little, you're elated. If you've done a lot, and particularly if you think that the cancellation is not really a cancellation but merely a postponement, then you may not be so happy. And as all of the ambiguities and uncertainties around this rule have been described by Allison and Robin and Brian, that's sort of the situation that we're in now. The rule may never go into effect, or it may go into effect as a result of a successful appeal or the judge deciding to lift the preliminary injunction or any number of other reasons. So that sort of uncertainty about whether and when the rule may go into effect raises obvious conundrums for you as employers. On the one hand, you could say, as an employee, you're no more productive to me today than you were yesterday, and I'm not required to do anything now, and maybe I never will be, so I'm not going to do anything. On the other hand, you could have said, I've done a lot of work to prepare this, or I've made announcements to employees and created expectations, and particularly if there's a chance that this is going to be implemented eventually, maybe I want to do something now and then just bite the bullet today instead of waiting to see. It seems to me, and I think to all of us on the line who've thought about this, the particular course that you're going to take is going to be the result of an analysis of a lot of issues. Legally, there's no requirement to do anything immediately, but as we all know in the area of HR, legally and what should be done or what would be in the best interest of the employer do not always necessarily correspond. And there are going to be a lot of other considerations, including non-legal behavioral drivers based on employee expectations that you're going to need to take into account and that can only be answered after consultation with a lawyer who is familiar with your scenario. So on the slide here, we put out four. We've tried to break it down logically. This is the four that we could see. It seems to me that for the first two, you're much more likely to be able to get away with doing nothing initially, although I would hasten to say I would not undervalue the potential reaction of employees. For as Brian mentioned a few moments ago, this is a particular rule that has had a lot of light shed on it by the press and by the Department of Labor, and so that there may be expectations, and you should not simply blithely assume that employees don't care or that it won't matter to them. 3 and 4 is harder to say what to do because it will either involve taking something away or alternatively potentially not affording a benefit to some group of people, creating a perception of disparate treatment. So if you've begun implementation and you want to take those away from somebody, you have to assess, is that going to be a more painful reality or outcome for me than if I just let it go forward? And it's going to depend on your financial situation and, again, the expectation of employees. If I leave it in place for those people who have already been given it, am I going to upset those employees who have not been given it because I haven't rolled it out to them yet? And is that perception of differential treatment going to create more or less pain? These are not easy questions to answer, and are going to be considerations that you're going to want to take into account after discussing them with your lawyer. Again, immediately, you don't need to do anything, but practically, that may not be the best course of action. So, Brian, you may have some additional points that you want to weave into that, but those are my general thoughts.
Yeah, no, Ron, I think that's right, and I think it's, as you said, I think that one of the things that we are already finding, and that I'm sure the people on the line are grappling with, is the point that you raised as between, you know, what the law requires you to do, which now in some respects, at least in the meantime, is that you are not required to do what you thought you were going to, but that you're going to have real human relations and personnel relations issues that arise out of this. I think it puts a real premium on messaging and explaining things. I think, you know, something that I know that we've thought about here, and you may be thinking about if you're on this right now, is also, you know, we've worked with a lot of employers who may not have been even necessarily grappling with issues that related to the salary threshold, but have also used the change that they thought was coming as a good reason and a good time to make other changes as it relates to classification. And so I think that an issue that will end up being thought through as well is, well, if that was your reason for making this sort of a change, not only what do you do now, but how do you explain what you're going to do now? Ron, do you have thoughts on, you know, for employers who have used what they thought was going to be this change as sort of a good time and a good opportunity to clean their house overall, as to how they can sort of communicate or how they can rationalize why it is that they are either going to continue with that or they are not going to continue with that now that the rules are not going into effect in the meantime?
Well, I think to the extent that you're clarifying potential misclassifications, the rule, even though it doesn't go into effect, affords employers an opportunity to go forward and at least clear the decks of those issues. You've begun an analysis, you've reflected on it, and I think that you can still explain that to people and move forward that way. So I don't see that the fact that the technical changes doesn't go into effect prevents an employer from putting a particular spin saying, we're going to go forward and do what we think is the correct thing to do.
Right. So as we're moving forward here, I think what a lot of this, well, and I should say first, look, obviously, some of the items that we are touching on right now, you know, we're touching on them in a very general way. I think what probably everybody realizes in particular is that as it relates to the appropriate classifications under this particular group of exemptions, you know, we're not dealing with something that's simple. While the salary piece of it may be fairly straightforward, the question of whether or not your employees are actually classified properly is obviously a much more in-depth analysis with fairly serious implications. I know that there are certainly employers on the line today, and if I would venture to say a fairly significant percentage that have dealt with wage and hour lawsuits. And you obviously realize that the stakes in those and the implications of those are fairly serious. One of the things that we have been spending some time in talking about even since Tuesday with our clients and companies that we work with also have to do with what are the strategies that you can employ now going forward, particularly as it relates to companies that were using this as an opportunity to really right the ship as it relates to their classification issues. I think that some of the take-home advice is that, first of all, whether the result of this injunction is that you are going to stay the course or that you're going to roll back what you were doing, subject to the appropriate messaging, I do think also that what you are likely to see now is a real premium being placed on compliance with the wage and hour laws, not just the salary threshold, which in many instances, particularly if it remains what it was, can be fairly easy to comply with. But I think that due to the light that has been shined on this issue overall, I think that you are probably entering a period of enhanced and increased sensitivity and awareness among your employees. I think you're going to see the same level of sensitivity and awareness and probably reaction among the plaintiffs' bar. I think that puts companies in a position now where, as compared to maybe a week ago, the litigation concerns that you may be facing, particularly if your classifications are questionable or a source of concern, I think the litigation risk and likelihood is probably higher now, if for no other reason than the fact that you have employees who now understand a little bit more about how this works. And again, we are certainly speaking with a number of companies about strategies as to how you can protect yourself, at least to the greatest extent possible. And ultimately, I think what this, again, reminds companies to do is to be working with, whether it's us or anyone else, it's not a plug for us, it's really a plug for making sure that you're doing the right thing, is to work internally and to work with your lawyers about what the appropriate next step is going to be, both from a legal compliance standpoint and also from the standpoint of what will strike your employees as being the fairest and the most appropriate outcome from Tuesday's decision. And again, keeping in mind the fact that Tuesday's decision, while it may be in place for a while, is really a placeholder, and we don't know for sure what will happen. And that pertains to the case that's pending in Texas, to say nothing of the implications of a new administration coming in, and that's particularly so if the case extends into that time period. And so we are certainly happy to advise you on that. I don't think that there is a silver bullet, as Ron's comments really demonstrated. For any given employer, any number of options may be appropriate. I don't think that there's a one-size-fits-all, and the key is going to be how do we message this appropriately while still making sure that you are complying in the way that you need to and leaving yourselves the flexibility to be nimble in the event that the decision that comes down ultimately is different than what we have right now. So with that, I think that we are going to open up the line to questions. I think we have one that is already on the line. Allison?
We do. We actually have a few people pose the same question, so I want to address this one first. Essentially, they were asking, if the court decides in favor of the final rule, will those changes apply retroactively or prospectively after the court makes its decision? And I'm going to throw this one to you, Brian, to answer the question.
I think the answer to that is that it would be prospective. I do not think that there is any reason to expect, and in fact, I'm not even sure that the court would have the ability to implement it retroactively. And particularly, and I think also even the question of retroactivity really also speaks to issues of irreparable harm, to the extent that the court had made a decision now that says, well, if we put this in place and later we don't decide, or later we decide that, really this never should have happened, that the irreparable harm of having it in place in the meantime would be so significant that we can't put it in place. So I think the short answer to that question is that what you would ultimately be looking at is a prospective implementation of it, not a retroactive implementation.
Okay. We have another question here. the question is, what is the possibility that the salary level, I suppose the salary level threshold completely supplants the duties consideration, the duties part of the test, and would that argue against making changes, that employers should not make changes now in order to be compliant with the current law? Can I throw that one to you, Ron?
Sure, and Doug Mishkin too may have some thoughts on this. I think that there's virtually no chance that the salary test will completely supplant the duties test. That would be contrary to the language of the statute that was passed by Congress in 1938. One of the arguments that the litigants made and that impressed the court was that the original language of Congress, and apparently its intent, was to focus on what employees were doing, i.e. the nature of their work, and not so much on the salary that they were being paid. And the court intimated, but did not decide, that perhaps the development of the salary test as opposed to paying somebody on the basis of a salary may have been something that could have been challenged earlier. So I don't see that there's any likelihood that the salary test is going to supplant the duties test. Again, that was a principle, or at least an important reason for the court's decision here. Doug, you have any additional thoughts on that?
No.
Okay, great. And then the next question we have here is what is our best estimate of how long the case will take to resolve? How likely will the DOL, how likely is it that the DOL will appeal the preliminary injunction separately from, I guess, continuing on with the main litigation? And, you know, I guess in summary, should everyone be planning for kind of a weeks-long, months-long, years-long delay? Doug, do you have an answer to that?
I do. Predicting is difficult, especially about the future. So what we know is the Department of Labor has until January 23rd to note an appeal. But think about the kinds of things one would need to know to predict what's going to happen, which is really what the question is asking. So for example, will the current administration appeal? If it does, will it seek expedited review? If it does, will the Fifth Circuit grant expedited review? One way or the other, will the Fifth Circuit affirm or reverse the entry of the preliminary injunction? Will it rule before January 20th? If not, will the new administration drop the appeal and drop the defense of the case? And then there's what will the new Congress do? So it's pure speculation to try to anticipate what's going to happen, and the time frame within which we would know those things is itself subject to speculation. The things that we know are the things that Robin referred to a few moments ago, which is President Trump would not be able to unilaterally revoke the new regulation, nor could the new Secretary of Labor unilaterally revoke it. The only way to undo the new regulation is if the preliminary injunction becomes permanent, which is one very foreseeable scenario, or the Department of Labor and the new administration institutes notice and comment procedures to promulgate a new regulation.
Right. And on that point, I would mention also, you know, one of the things that we've been sort of engaging in here on our end is a little bit of an exercise in reading the tea leaves, which I realize is what we're all doing right now. I would note that, and I'd note also that I think the landscape is different now than it was in the example I'll mention. But we saw a similar and frankly almost identical exercise to the one that we're seeing right now almost exactly 2 years ago in the context of home health care. There's an exemption there referred to as the companionship exemption, which is just another exemption under the FLSA. The Department of Labor, much like it did now, issued updated regulations that as a practical matter would cause companies in that industry to no longer be able to take advantage of that exemption, much in the same way that the implications are fairly drastic here. You had the same process that played out. You had a challenge by a range of business organizations. You had a request for a preliminary injunction, and in fact, prior to that, a temporary restraining order. And in that instance, like here, the court granted the request for a preliminary injunction. And ultimately, the Department of Labor in that case did not appeal that decision. Ultimately, in fact, the Department of Labor lost at the district court level and then, of course, appealed that decision, ultimately successfully. But you did not see an appeal of the preliminary injunction now. Now, again, I want to be very clear that I don't think that you necessarily can read those tea leaves to mean that they will not appeal here. I think the landscape is different. I think that the fact that you have a forthcoming new administration that is likely to bring with it, obviously, some fairly substantial changes may really dramatically change the landscape as to whether or not the Department of Labor feels it's necessary to appeal now. But I do think that it is worth noting that in a situation that is really on all fours with what we had, at least in terms of the legalities that were at play, you did not see the Department of Labor appeal. I think in terms of the time frame, I think that case then went on for a few months, not much more than that, until a final decision was made. Again, we don't know whether or not that tells us what will happen next, but it may give us arguably some insight.
Okay. And we do have another question. If the injunction is lifted or a decision is issued in favor of the final rule, will there be a time of adjustment, a period where employers will have time to implement the final rule, or would the expectation be that employers adopt these changes immediately? And Robin, do you want to answer this question?
Sure, I can take that one. So that depends a lot on what route we take to a final outcome. And I hate to sound like a broken record, but ultimately the answer is we don't know. But if a change comes through, for example, notice and comment rulemaking, we should get a lot of notice, and then we'll know what our implementation period looks like. If it's through the court system, that's really up to the court. Presumably the court would give some amount of time for implementation, but we don't know how much time that would be, or if they would even do that. We would hope they would, but you never know. And if something comes through the Department of Labor, presumably, or through the Congress rather, we'd presumably have some notice that something was going on there. So ultimately the answer is that we don't know for sure. We would hope to have some time, but if you're sitting there with a plan in your back pocket and you're thinking you don't want to implement it right now, I think our advice would be don't throw away that plan quite yet. Be ready to be nimble if something does come down the pipeline. You may need to implement it quickly, but at this time we just don't know how much time you would have to do that.
Great, thank you. And another question we have is, when are the New York Department of Labor regulations due to take effect if passed? So right now it's actually in the very preliminary stages where the notice and comment period for these regulations ends on December 3rd, 2016. The way that the regulations have been proposed, there was a targeted increase as of December 31st, 2016. And if that's the case, that means that you could see the effective date of these you could see the New York State Department of Labor rolling out the regulations based on the notice and comments that they receive pretty quickly. And that might be the case. They might decide to extend it. That's something that we don't know, and I don't know if this decision would ultimately impact what the New York State Department of Labor does. So the truth is that we actually don't know, but we can anticipate that it would be happening very rapidly, considering that the first threshold, the first change to take effect would be the end of this year. And another question we have is, if employees have already been given pay increases, could these increases be taken away from employees without any legal ramifications? And Brian's going to answer that one.
Sure. I think I would say a few things on that. The first is that, look, assuming that you are dealing with at-will employees, meaning employees who do not have a contract for a specified duration with your company, and you've not otherwise guaranteed them something by way of an agreement. The short answer to that question is yes. I mean, you are one of the rights that you have as an employer of at-will employees is to change the terms and conditions of their employment, subject to your discretion. I would note, but I would say a few things about that. First is one thing to keep in mind, and this is really sort of a technical administrative point, is that in certain states, in many states, frankly, a change like that, in particular a reduction in somebody's salary, comes along with a requirement to issue a particular notice. I know in New York that's the case. I know of a number of other states where that requirement is in place. So the first thing is that you want to make sure that you're going to do that in a way that's compliant with the notice requirements that may apply in the regions or the states where you do business. I would mention also that, and I know that this is probably something that you've already thought about for the person who had sent this question in and for everybody else on the line. Obviously, you want to be sensitive to the personnel relations implications of something like that. If you are considering essentially keeping salary increases in place, salary increases that were put in place because you thought that the new rules were going to go in place, but in the back of your mind, which this question obviously suggests, in the back of your mind you're thinking, well, if things change or if the court, actually if they don't change, if the court says, yeah, this preliminary injunction will now be permanent, and your thought is when that happens, then we'll just roll it back. One thing you may want to consider is messaging that now up front and letting employees know, okay, here's what's happening, here's what we've decided to do as a result of it. We understand that this is not a permanent, this is not a final decision, and so we're staying the course for now, but please understand that this may change. Again, I know that goes to a messaging issue, in some respects less than it does a legal issue, but frankly I think we probably all realize on the line together now that the implications, even though you may be doing something that is perfectly lawful in reducing or rolling back a salary increase later on that you had implemented now, whether it makes sense or not, there are likely to be legal ramifications or at least some consternation among your employees. And so I think that giving them a heads up as to what the future may hold now is probably a good course.
Okay, thank you. And we have one final question before this ends. If the preliminary injunction is reversed, does the final rule go into effect immediately, or will the litigation continue? So, Ron, do you have an answer?
Sure. So the preliminary injunction is extraordinary relief, which is granted within the context of the other action, and the court could lift the preliminary injunction and the lawsuit would potentially still go on. Lots of times, though, the real object of the litigation is the issuance of a preliminary injunction, and so it's impossible to say at this point whether or not the litigants would continue to pursue it if they couldn't get a preliminary injunction, although certainly they would have the right to continue the litigation.
Allison, it's Doug. I hear in that question and the question resembling it from before a concern about whether an employer would be able to implement changes quickly enough. And my sense is, again, nobody can predict what the Fifth Circuit or even the district court might do in lifting the injunction, but I wouldn't let that drive the decision about whether to go forward with changes now or to keep changes that you've made or to not. I think that would be the tail wagging the dog. I think deciding what to do for your organization, that's a decision you should make based on the kind of factors that you've heard discussed. I wouldn't make decisions like that based on fear of not having enough time to respond to a court's ultimate decision.
Okay. And we do
one
have
other
time
option
for one. Sorry.
I was just going to say one other option that Brian didn't describe. If somebody wanted to implement the rules now, you could, in essence, red circle the rates and tell people, again, it's a messaging issue, that we've implemented it now. If for some reason the regulations don't go into place, this may mean that you're going to forego a raise at some point in the future so that we can reestablish the correct relationship. So there's lots of different options that people can think through in terms of what fits best within their culture.
Yeah, I think that's exactly right, Ron.
Okay, and I think we have time for one final question. What's the likelihood that the court will reduce the proposed threshold, the salary threshold, from approximately $47,476 to something lower? And the answer to that is there is no likelihood of that. Under the Administrative Procedures Act, this rule had to go through the notice and comment period, and ultimately the agency made the ultimate decision as to what level they would set the salary threshold, and the court at this juncture does not have the ability to lower that in this lawsuit.
Yeah, ultimately that really resides within the province of Congress. The court can make decisions as to whether or not, but they are not in a position to start changing the law itself or revising it. If ultimately this does not go into place, or if Congress decides to make a change, they can do that, but it's not within the court's authority to select its own threshold.
Okay. And we do have a few more questions in the queue, which we will follow up on as soon as this presentation is over. We'll be responding to you within the chat function itself, or via private email. So if you do have any other questions, please feel free to insert them into the chat function, and we can get back to you on that as well.
Great. And again, thank you all very much. We've had a great response to this webinar, to the updates and the alerts that we've sent out. We realize that this is a real-time issue for all of you on the line. We are happy to help you with it. We're happy to consider the options, consider the strategies, talk in more detail. We realize, of course, that this is going to be an issue that's ongoing for you as time goes on, and we are certainly happy to work with you on those. And again, thank you for joining in, and we hope to talk to everyone soon.